Thank you, Mr. President. You know, the work that we do here in the Parliament is important on all fronts, but this bill has special meaning to me today because it affects what we sometimes refer to as the ordinary Jamaican. It is a bill that many Jamaicans, most Jamaicans can relate to, and it's a bill that those who sometimes are struggling to meet the needs of their families can relate to. And that is why I thought it important that I should rise to talk about the bill and to support it. And especially for women, because in Jamaica, almost 50% of our households are led by females, and over 70% of microloans are issued to women. And what microloans do, they provide not just economic independence for not just women but the family, but also it puts them in a position to provide for their families, which in itself is empowerment. And that is really important, because without the empowerment and without the provisions for the families, our society would suffer. And I do hear the criticisms of the bill. I do hear that it may have a negative impact on the financial industry. I do hear, that the penalties are too many. I hear that we could stifle a growing sector. But what is most important for me and this bill is that it will stop intimidatory and predatory practices by lenders for the average Jamaican. And for me, that is more important. Now, when you look at it, there are many unbanked persons here in Jamaica, lots of them. And this is something that we have to look to see how we're going to alleviate that issue. How do we deal with the many persons who are still unbanked? And you'll see some of the smaller banks in the country, they're pivoting to put in programs and systems that will attract persons who don't necessarily trust the banking sector or understand the banking sector. And it may mean, I've heard both my two colleague senators, Senator Webby and Senator Crawford, they spoke about the Grameen banking in Bangladesh, popularly called the barefoot banking. And maybe it is something that we have to look at in terms of how micro-lending, micro-crediting is done in Jamaica, because that system is done on the basis of trust and mutual accountability, and within the context of the concept of cooperatives. And maybe that is something we need to look at. But in the meantime, what we have in Jamaica to work with is a system where microlending is a for-profit business. And the responsibility of any government, and sometimes when we talk about government, we forget that it includes the opposition. The responsibility of any government is to protect its citizens, but especially to protect the most vulnerable of our citizens. And as everyone here has spoken, has mentioned, the majority of persons who turn to microlenders, microcreditors, are part of the most vulnerable. But we often talk about it within that context. But we also forget it's not just the vulnerable who need small loans. A few months ago, I remember it was a Friday evening, leaving Senate, heading home, and a former colleague of mine, we taught together at Waterford High School, he called me. And it was a strange call because not someone that I speak to very often. And he said to me, "Natalie, you have to help me." I said, help with what? I thought something had happened to a family member or something. No, what had happened was he saw an opportunity to start a business. He took a loan to buy a van to do delivery business, to do delivery of goods. And he's a teacher, remember that. So he's educated. He took a loan and did not realize / know what the interest rate was and how he would have been affected. So it's not just the poor and the under or uneducated who are affected by this. It's a wider group of people who are affected by this. And what had happened was, it was Friday, and if he did not pay the loan by Monday, they had already taken the vehicle the Monday before. This was Friday, and he had until the next Monday, or he wouldn't ever get back the vehicle. And what he said was, he had the money in his hand. He has an adult child, and he took the entire amount of the child's salary. And he was headed there to pay. And when he got there, they closed at 2:30. He got there at 2:35. They told him he was too late. No, and he said, what is the government doing to protect people like me? So when this bill was being handled in the House on Tuesday, I said, turn on your television and see what the government is doing to help people like you. And by people like you, I mean anybody who falls victim out of a desperate need for some help. Now, in addition, though, to the legislation, to the bill before us, there should also be a call to the banks, to these banks to pivot to assist the people of Jamaica who need their assistance. It cannot just be high levels of profit without any assistance to people who legitimately want to make a better life for themselves and their families. And I'm so sure you will support me on that, Senator Bunting. You know, it is important that our banks not just look at the supernatural, the really big profits they can make, but give back to the society, because sometimes it is these persons who don't seem to have what it takes. They have a record of repaying their loans quite well, and we need to really and truly look into how we can help to make that even better. Now, you know, Senator Crawford, I heard what you had to say, and one of the things you spoke about is that you didn't feel that the legislation was purely for the benefit of just helping out. And that reminded me of when I was in high school. One of the things I disliked about high school English was when the teacher says, what was the poet thinking? What was the what? Poet. You know, you read a poem, and then the teacher asks you, what was the poet thinking? Well, I couldn't do it because in third form I wasn't so good at it, so I couldn't choose it as a subject. But when they ask you what the poet was thinking, I got stressed at that question, because never once the teacher was able to tell me that my interpretation was correct. And then I thought it was foolish, because I wasn't in the mind of the poet. So I don't ask me what the poet was thinking. This is my interpretation of what the poet was thinking, and I'm always wrong. So, for you to assume, Senator Crawford, that the reason behind this bill is only to meet an obligation for... Sorry? Yes. But what I'm saying is we can't make that assumption, because the responsibility of the government is to protect its citizens. And that protection, and by government, it's opposition, and it's the sitting government. And it's our job. That is what we're here to do. Even though we're in the upper chamber and we weren't elected to be here, we were selected to be here, we still have that responsibility. And if tonight, I hear a lot of complaints from the opposition about this bill, but I am going to go home tonight and I'm going to sleep well to know that I have contributed significantly to helping vulnerable Jamaicans to have a better life. And this is where, though, if you look at the bill, It talks about the fact that there's need for information to be disseminated. And that's one of the things I'll use this platform to call for, is for us to ensure that the basic tenets of this bill, they're circulated. We can put out the information so everybody knows what they're up against. I think it is very important to do it for all bills, but especially for ones such as this. And one of the things that I think we should always think about is, and I'm always curious, as a new senator, there are lots of things I don't understand. And while I may be going through the standing orders, and every week I come in here and I try to understand especially how the systems work in the Senate, one of the things I don't understand is, if you are so vehemently against the bill and what it sets out to do, and so much time is spent condemning what happens in the bill, why do you then still vote for it to pass? And I'm speaking from a place of ignorance, that I don't know and I don't understand. So, and I'm asking a legitimate question, because I think we all know deep in our hearts that this is for the betterment of all Jamaicans. But we should not use matters such as this to grandstand. Let us just get the work done for the people of Jamaica, and let us just make every effort to protect the most vulnerable among us.
Mr. President.
Thank you, Senator Campbell Rodriguez. Senator Fraser-Binns.
Thank you, Mr. President. Mr. President, before I start, I do feel obligated to say something in response to what Senator Rodriguez said. Because you see, Senator Rodriguez and you and I coming from very far in different places, you would appreciate that the point that someone raises a concern or makes a comment on the bill does not mean that there is full disagreement. In the spirit of democracy, and what democracy requires, is that both sides must exchange ideas, must exchange recommendations, and in the end, a consensus is arrived at. I don't believe, in fairness to Senators Bunting and Crawford, that at any time in their presentations that they stated that they are not in support of the bill. There are aspects of the bill that they have contention, which is their right so to do. But I do not believe at any point that they stated that they are not in support of the bill. In fact, Mr. President, I rise to echo the sentiments of Senators Bunting and Crawford that we support the bill. We believe that it is a bill whose time has been long in coming. But we also believe that a better bill would have ensured that there is a balance in the protection of the interest of both the lenders and the consumers. And I believe that is the point that Senators Bunting and Golden, did I just say Golden? Senators Bunting and Crawford were making when they spoke. And I too share that. I share that, you know. Come on. Mr. President, I'm going to ask you to help me because I made a commitment to Kavon about my presentation. But remember, Kavon, you're going to have to help me to keep that commitment. Okay. So as not to repeat the information that has been shared by colleagues on both sides, Mr. President, the undisputed fact is that this bill concerns a sector which really touches most Jamaicans, particularly those who are most vulnerable. But we also accept that it is an industry that lacks regulation. It is an industry where the treatment of borrowers vary. in a conversation I had yesterday with an industry player, he said to me that there are some persons within the industry, those would have been approved by the minister under the Money Lending Act, who their fees, for example, are, for want of a better term, regulated. Their fees are capped. But then there are those who do not operate under the Money Lending Act, and their fees are quite exorbitant. Their interest rates are quite exorbitant. And so what you find is that it moves from one side to another, and there's no middle ground, and hence the need for it to be regulated, and we accept that. But I want to say something, and I thought this is where Senator Rodriguez was heading. Because the growth in the microcredit or the microfinancing sector came about because in so many ways, the commercial banks as we know them have failed people. A little person who doesn't have a whole set of documentation cannot go to the bank, a commercial bank, and get a loan. It is very difficult. I know that some banks, and I'm not looking anywhere, have in recent times tried to see how best within, observing the standards of knowing your customers and the AML, have tried to make it a little easier for customers. But the truth, Mr. President, is that there remains a significant percentage of our population that is unbanked. There remains a significant percentage of our citizens who are unbankable, who cannot provide a proof of address. And the proof of address that they can provide is a letter or a recommendation from a justice of the peace or from a pastor. The question then, is that acceptable to our commercial banks? In my experience, the answer is no. These microcredit facilities are more likely to accept that kind of proof of address. And so, while we look at this act and while we put in place regulations to ensure that the industry operates in a very balanced way to the benefit of all the players, the fact is that it is also an opportunity for us to make a call on the banks that they become more friendly. It is an opportunity for us to call on the banks that they get back to the core business of banking. When I was in primary school, and I won't say when, but in Brownstown, I remember a certain building society used to come to the school, I think it was every Friday, and you put a little money and you get a little blue book. I don't know if that happens anymore. These are the things. I know recently I heard about an institution that is going to be starting some mobile banking, but these are the things that I believe that we need to do so that all Jamaicans are not just bankable, but have access to our commercial banks. Mr. President, the truth is that whereas I would have wanted to see certain measures, which I will speak to in a minute, in this bill, at the end of the day, we believe that it goes some way in righting what can be deemed as a wrong, in putting some measure of predictability, and certainly in regulating this industry that has served so many Jamaicans who otherwise could not have been served. But I want to make a quick point, Senator Crawford, and that is while we talk about the fact that this is a system or a sector that is utilized by vulnerable Jamaicans, this is also utilized by professionals. Because I was told that by one of the stakeholders that their clientele include lawyers, include doctors, include teachers. And these are persons who normally would have the proof of address, would have the recommendation, would have the salary, hence the salary deduction. But what the microfinance entity provides is a speed, and in some cases, it is less restrictive. And so there is, in fact, a benefit to be derived from this sector, and hence the bill, it is something that we support fully. I also, and Senator Crawford raised it, so I will not belabor it, but I just want to say that what it also brings to focus is a piece of legislation that was passed about 7 years ago, the security interest in personal property. And I'm using this opportunity, Mr. President, to ask the government and all stakeholders to utilize that a little bit more. The intent of the Security Interest in Personal Properties Act was to ensure that persons who don't have the regular collateral, like the land or the house or the car or the money in the bank, but they have their crops or they have their music catalog or they have their animals, that they could access loans, and not just from the microfinance institution, but from commercial banks as well. A presentation I did some time ago, I spoke about the fact that the late Michael Jackson was able to get a loan using his music catalog. I believe that Jamaica, being an entertainment-rich country, a country that has done so well in the arts, really need to be using the SIP a little bit more. And so I'm making a call for the government, along with all our stakeholders in the private sector, to do more to ensure that Jamaicans avail themselves with the use of the Security Interest in Personal Properties Act. And with that said, Mr. President, I just want to make some quick comments relative to the bill. And I will start at page 7, and I know the minister is not in here, so I don't know if Minister Campbell she's listening. Okay, thank you, sir. The substantial shareholder, I would like for the minister just to explain, because it defines a person, the substantial shareholder is defined as a person that has 20% or more interest in the licensee. And I wanted to know why 20%. I don't know if there's another legislation that exists that they pull this out of, or what was the reason. I just want to understand the reason for the 20%. It's page 7 on the definition clause, substantial shareholder. Then, Mr. President, I want to look at page 11, part 2, clause 4, subsection 3. That speaks to every 3 years for there to be a review undertaken by, it says at least every 3 years, there shall be a review undertaken by qualified independent experts of the effectiveness of the supervisory framework as set out under this act and the process and the procedures carried out. And I thought that that is a very good measure, and I support it fully. The contention I have, however, is at the concluding sentences, where it says that the report of this review shall be provided to the minister and the supervisor. Why do I have that contention? I have that contention because earlier on it spoke to an annual report that is tabled in the parliament through the minister. No, this is a new dimension. This is something new, a new paradigm that we're entering into. And I thought that for good measure, that the report should come back to the parliament. And I wondered what was the reason why the report goes to the minister and the supervisor and stays there. I'm recommending that that report should also be tabled in the parliament through the minister. At page 14, under part 3, and I seek some clarification here, because it says at clause 10 that an application to obtain the license to operate a microcredit institution shall be made to the supervisor. And then it goes on at part 8 to say that they have proof that the institution is registered as a company pursuant to the Companies Act. Now, the question I have here is, so you have commercial entities that are registered either as a company pursuant to the Companies Act or as a business name under the Business Registration Act. Business Name Registration Act. And so I wanted to find out, and I hope the minister in her conclusion can clarify for me whether an entity that is registered pursuant to the Business Name Act can engage as a microcredit entity, or is it just a company registered under the Companies Act? And I completely understand you can have a one-man company, but there is in fact a difference between the Business Registration Act, the Business Name Registration Act, and the Companies Act. At page 16, clause 12, it speaks to the license to be prominently displayed, and the penalty for not displaying, same as provided in the 4th schedule, I believe is $1.4 million. I know the minister, 1.5. The minister spoke about it this morning, but if I heard correctly, the penalty has not changed. And again, I wondered, and I really hope the minister can address this in her closing, what is the reason for that provision? Because there are presently legislation that you have to get a license, it has to be displayed, but the penalty is not like that. So take, for example, the GCT Act, the General Consumption Tax Act. At section 32, it speaks to the fact that once you are registered, then you must display your certificate. But if you fail to display your certificate, then one is that you're given a warning, and if you fail that warning, then you can be penalized, but the penalty is graduated. So after the first breach, I think it's $10,000 and then it graduates. I think there are 3 levels of it. And I want to recommend that instead of the approach that is taken at clause 12, that the minister would consider the approach taken in the GCT Act at section 32. At clause 17, subsection 4, that speaks to revocation of a license, it says that before an approval is revoked, so revocation of the approval, before an approval is revoked, the minister shall give the person concerned notice in writing of the intended revocation and shall afford the person an opportunity to submit to the supervisor within 14 days a written statement of objection. For clarity, out of an abundance of caution, I believe that the provision should state that the supervisor shall state the reason for the revocation. And so I'm proposing that the amendment is made, and in the committee I'll propose the wording for it, but the word reason should be inserted in the provision. Yes, reason should be given. I believe, Senator Brown, that it is assumed that the reason will be given in the notice, but we do not want to assume, which is why I say out of the abundance of caution. At page 29, clause 26, it speaks to the suspension of a license. And having read it, it talks about, well, let me go back to 25, because 25 and 26 must be read hand in hand. In 25, it talks about the measures that the supervisor can take, which is to issue the warning, issue directives, suspend the license pursuant to section 26, and the revocation of the license. But at 26, I wondered whether it would make for better reading and a clearer understanding of the process if we say that before the supervisor suspends the license, then he has to do A and B. I do not know what is the intent, or what was the intent or the thinking of the drafters, but in my mind it makes sense that if there is a breach and the breach can be corrected, then the supervisor should warn the licensee that there is in fact a breach and give the licensee the directives to comply. And if it is that the licensee refuses, then the license is suspended. And from my reading of section 26, I do not see that. And even Senator Sinclair, when you turn to page 30 and you read through at subsection 3, it still does not clarify it does not give me any comfort relative to the concern I have in terms of the process that is followed for the revocation of a license. Yes, it just says you should give notice, but it doesn't say that you should issue a warning first or state that the breach must be done and given the directive. Still at clause 26, sir. Subsection 3B, speaking to the suspension of a license, it goes on to say that indicating a period, that is the supervisor, indicating a period of not being more than 30 days after the date of service of the notice within which the licensee shall have an opportunity to be heard, and in relation to which the licensee may submit to the supervisor a written statement of objections or make oral submission to the supervisor. So what it does here is that it gives you a specific timeline within which you must respond. But interestingly, what happens after the response is that there's a hearing. But what it does not do, it does not give you a time within which the decision of the hearing should be known to the licensee. And so I am proposing that a specific timeline be given at subsection 5 by which the supervisor should inform the licensee of the determination coming from the hearing. And it is not unusual, because if you look at clause 41(7), I think that has to do with the Consumer Affairs Commission. It does provide that a decision has to be made within a particular timeline. So it is not a new provision, it's not unusual, but I believe for certainty, instead of saying reasonable time, that a specific time should be given. And I'm trying to move as quickly. And Senators Crawford and Bunting spoke about clause 45, so I will not follow through with that. And I support their position. And also, I want to just say at 48(4) that instead of the optional may, that we use the mandatory shall, because of what is being asked. All right, so I want to know, and I'm actually sticking to my commitment, Senator Gale. The review, it speaks to a proposed time frame of 5 years for the review. I want to pull that in for 3 years, not only because of the reasons that were articulated by Senator Bunting, but also because in the front of the Act, when we speak about reviewing the regulatory framework, we spoke about a 3-year span. So for uniformity, I think it makes good sense that we tie in all the reviews at the same time. So, and it makes good sense, because if you have the review from the regulatory body, then the joint committee of Parliament that will be set up to review the Act will avail themselves with the findings of that review so that a complete picture can be had. Maybe at the end of it, we may decide that maybe the BOJ is not the body to regulate it. Maybe it should be the CAC or the FSC or some other entity that is to be established. So I think for good measure and for uniformity, 3 years would be a good time. Now, let us look quickly, Mr. President, at the second schedule. The second schedule at section 1, subsection 2, speaks to the composition of the appeals tribunal. Again, I echo the view of Senator Bunting in terms of the very limited scope that the tribunal have. And perhaps we probably just need to find some other entity and merge it with, because setting up a tribunal just to really look at fit and proper, really, you know, I just don't believe. Yeah, appeal for, exactly. So, but notwithstanding that, as it is now, the proposal I'm making is that if you're going to have an appeal, then you should have a representative from the body that it governs. And I'm not seeing anything here that speaks to a representative from the microfinance sector. And I'm recommending that in addition to all the persons who will have experience in law and banking and finance, that it includes a representative from the microfinance industry or sector. I also want to make a recommendation at section 6 that speaks to the tenure. 2 years? I would like to know the reason for 2 years. I mean, I've seen 7 years, but I've not seen 2 years. I think 2 years is really a short time, particularly for new legislation. And I would propose in this instance 5 years, that the tenure is 5 years. So that's at section 6. I believe that both, well, I think Senator Bunting more than Crawford spoke to the whole penalty, which we find were not all, which are more prohibitive than anything else, and did not do much did not augur well for the industry. But I spoke earlier about the display of the license. I think that is something that really has to be reviewed or should be reviewed. I also want to look at 16.2 that speaks to a person who knowingly or recklessly advertises information which falsely implies or explicitly states that a person is licensed under the Act as a microcredit institution. $1 million, again, and I'm taking a different view now, but I think $1 million is too small a fine. Because if the fine for not displaying your registration certificate is 1.5, then the fine for knowingly deceiving John public should not be less than that. And so I'm recommending, and I don't know how much leverage or what instructions the minister can get from the Minister of Finance, but I believe that this fine of $1 million really should be increased to make it sufficiently prohibitive. Pardon? I see I'm getting some support from Senator Rodriguez and Gale in that regard, so I believe that it will be something we can look at. Mr. President, I made a commitment to Senator Gale, and so the others that I have, I'm sure I can deal with them in committee stage. And with that, Mr. President, I just want to echo the position of the opposition that we are in support of this bill. We believe that with a little more time, we would have been able to make this a more balanced, comprehensive, and a better bill for all Jamaicans. But it is what it is, and we do give our support, and we look forward to the discussion at the committee stage. If it pleases you, sir.
Thank you, President. Senator Binns, you could always, I've made a note of the suggestions, and you could just restate them in committee. Senator Campbell.
Thank you, Mr. President. Mr. President, given that this is a part-time job, I'll take my 2 minutes and be gone. Mr. President, I will take I'll take a very brief overview of the provisions, but I find myself, oddly enough, agreeing with the latest senator to join us. I don't very often agree with bankers in whatever they do, but I find myself agreeing in certain respects. Mr. President, this piece of legislation, if we are to believe what was said in the lower house, it seeks to protect consumers. That's the main thrust. So that if we have a debt under the MCA. It sets out a scheme which is supposed to offer some greater rights or stronger rights if you're dealing with this regulated debt. But how much is it? I would have hoped that at some point in the drafting of the provisions, we would have contemplated a scheme where we would have determined what it is, how much ought to be contemplated as a sum to be included as a regulated debt. And one would have hoped that the drafters would have opened the scheme so that we would know, for instance, if a consumer fell into arrears, is there an obligation on the part of the lender to, in the first place, issue a default notice and then go on to give him time to bring his account up to date before legal action could be pursued? Is there a provision where, under these regulated agreements, where the creditor is obliged to send arrears letters to indicate to the borrower that he's falling into arrears and what action he is to take to bring himself in compliance? And I believe that Sir Alexander Bustamante, who was one of the prime movers in this particular area, would have wanted us to contemplate such action, because in his day, when he made loans, I'm sure he didn't practice some of the things that we are told that these present-day operators are doing. Is there a provision where, in light of technology, where agreements are done by way of the internet and using such agile technology, that one would allow the consumer to benefit from a cooling off period once he executes the agreement, and if he were to then get advice later on which suggests to him that he is likely to be prejudiced by virtue of what he has signed, then he could then go back to the potential lenders and say to them, well, listen, I want to get out of this agreement. And, Mr. President, I'm yet to see, forgive me if I'm wrong, but if these lenders, micro-lenders, are to grant mortgages, would they be exempt? Would the provisions exempt them from provide them with some exemption? What is the case where a borrower wants to repay his loan early? Is he going to suffer in any way? And in terms of the adjectival part of the agreement, the procedural requirements, I would have hoped that we would have contemplated the inclusion of such provisions in these agreements, which would provide a more fulsome protection for the consumers. Because if we accept that that is what it aims to do, then I believe that it falls a little bit short. Notwithstanding that, Mr. President, may I commend the bill to this honorable Senate and say that, like my friend Senator Binns has said, that it's been a long time coming. Thank you, Mr. President.
Thank you, Senator Campbell. I think that there is one speaker left on this side. No? That's it? Minister?
Thank you.
Sorry, Minister. Go ahead, Senator Longmore, please.
Thank you, Mr. President. I hasten to just quickly add my voice. I know it's a long day, but I didn't want this discussion, this very important discussion on this very critical bill to pass without just really recognizing how important it is for some members of our society. You know, we are dealing with very serious times, socially, emotionally, and of course financially. And one of the fallouts that we're seeing from these very trying times is the very significant predisposition to crime and violence and a lot of the very negative fallouts. Money, a lot of times we are raised to hear that money can't buy happiness, etc., etc. But I can tell you that money can help with misery and money can help with pain. A lot of families, and my colleague Senator Rodriguez mentioned the importance of this bill towards women. But, you know, an incident happened where I sat in my car and I saw a lady, probably in her early 30s, and you can see she had 2 children with her on the side, and she was basically trying to peddle some hand sanitizer and wipes. And I sat there because there was a line of traffic, and she approached, I think, at least 6 cars in front of me, and everybody basically shunned her. And I watched as she walked down to the rest of the traffic behind me. And not one person decided to support. And I could just see what this meant to her in terms of the effort and what she's probably trying to provide for her children. A lot of these microfinancing opportunities could make significant changes in the lives of people who are not able to meet that standard of elevation. It is what a lot of times Jamaicans grow up throwing them partner, and the partner draw is what pay the school fee. And that school fee goes to elevate that family through education out of poverty. I am imploring that the persons who are implementing and seeking to provide these microfinancing opportunities, the institutions, that they probably consider giving preferential policies, preferential interest rates to single mothers, to persons who, when you look, you can see that they have been trying at a particular business for a long time and they only need that little extra push to get them over the edge. That is the meaning of this bill, and making sure that Jamaicans who are not usually able to access that little help to get over that bump can do it. And we're trying to ensure that it is done safely and in a way that sees the regulations of persons not being taken advantage of. As I said, I just wanted to make sure that that bit of it, I wanted to mention clause 43, 46, 49 in different ways, but they have been addressed by other members. But I also want to focus on clause 53, where the protection against lenders using force and aggression to retrieve the monies, and recognize that a lot of persons who are usually accessing these facilities are at their wits' end, can we seek to have some amount of humanity, for want of a better word, in terms of how we give that extra help to allow these persons to be able to fulfill their obligations. I have to add my voice to clause 46 in terms of the provision, and 49 for the provision of full disclosure of the agreement that persons who may be in a desperate state seeking these assistance, that they are fully provided with the information as to what it is that they're signing on to. And so those are my few comments. As I said, I would have been a bit more detailed, but we have had significant contributions. But I just want to underscore my support for this very critical bill for our people. Thank you.
Thank you, Senator Longmore. Minister.
Thank you, Mr. President, and thank you very much to members on both sides who have contributed to the discourse today, to the debate on what is, I believe we all agree, an important bill, which is long overdue. Mr. President, if you just permit me to raise some of the, or address some of the issues which have been raised in the debate before we go into committee, so that, if possible, where it is clear where we will be accepting amendments and where not, then it might help the proceedings in committee to move a little more efficiently. Mr. President, of course, I had earlier introduced the amendments which are on the tabled sheet, but in the course of the debate, we have taken on board some of the matters which have been put forward. I want to start with the reference to Clause 6.1c. Clause 6.1c is the provision which deals with confidentiality. 6.1 deals with confidentiality, and we have accepted the proposal that we also seek to move beyond investigation into prosecution, and also that we make more clear the issue of the appropriateness of disclosure in the circumstances where a court order is presented, and of course in respect of yes, in respect of those two matters primarily. So there will be an amendment wherein Clause 6.1c will be deleted and substituted with the following words: to disclose, other than for the purpose of the investigation or prosecution, so we'll insert the words or prosecution, of a financial crime, or in relation to the contravention of a licensee's obligation under any other enactment, and then we'll insert, or upon the presentation of an order from a court of competent jurisdiction, and then the remaining words will remain the same, any information obtained in relation to the performance of their duties under this Act. So the points which have been raised by Senator Bunting are taken on board in respect of an amendment to 6.1c. The next amendment which was proposed was in respect of 9.3, which deals with the consequence of unenforceability. But this we won't be taking on board, because the provisions of 64 and 65, which speak about the transition and savings, the transitional period and the savings clause, we think there is sufficient clarity to the balance between the consequence and the savings clause. So the next one which was put forward was the matter of was in clause 25.1, and this was where the request was made that we make it express that the condition of a license should also be addressed. The condition of a license should be part of the reasons for which a supervisor should be able to take regulatory action. So while it is already addressed in the bill because it is an offense to breach, the fact is that it can be made more clear and more easily provable and enforced. So we will be inserting the words after contravening. So where after the words contravened or is contravening, we will be inserting the words a condition of its license, comma, and then the language remains the same, a provision of this act or any other enactment under which it has an obligation, direction, rule, etc. The request which was made in respect of Clause 26, and in fact, two were made in respect of Clause 26. One was the issue of the reference to the substantial shareholder, and the other in respect of the fact that all that is required for a supervisor to possibly suspend a license is that the shareholder or officer be charged with an offense. So both issues will not be amended. Neither issue will be amended. To explain, the issue of the substantial shareholder is in fact already addressed under the Banking Services Act. It is not only already used as the basis for fit and proper assessments, and there the threshold or the trigger point is 20%, which has moved from 10, I understand. But it is also a part of the AML framework. And ultimately, it will be used to enhance the definition of the ultimate beneficial owner under the Companies Act. As we all know, further amendments to the Companies Act are coming, again, for compliance with the action plan under the AML CFT framework, and the substantial shareholder will be there. The fact is, a substantial shareholder is recognized already in that framework as a shareholder who is able to exercise significant influence, even if it is that they don't hold that 50% threshold. That is seen as a controlling interest. That world is a changed world, and it will start to reflect itself in future legislative amendments, but it's already reflected in the Banking Services Act as well. The phrase is already located there. The function of someone being charged, and again, this is linked to the point of the AML CFT framework, etc., as juxtaposed with the pace of our courts. So in the circumstances where an officer or a substantial shareholder, one exercising influence over the operations of the company, is charged with an offense involving fraud or dishonesty, and this is in the assessment of the supervisor, a circumstance which puts its clients at risk, its consumers at risk for one reason or another, even if it could even be the business at risk because of the perception of other financial institutions. One could, if no action could be taken, even in appropriate circumstances, then you could find circumstances where, as we have now, persons are charged and 5 years later you're still waiting for the case to be prosecuted. And in the meantime, who bears the brunt? Either the organization, the company, or the customers or clients of the company. And this is quite narrow. It's offenses involving fraud or dishonesty, and this therefore is not being taken on board. The policy is to empower the supervisor. It does not say that the supervisor shall. It says the supervisor may, and it would certainly be more appropriate, it is felt, that this be left to the discretion. Similarly, in respect of Clause 30, sub 1 and 30, sub 3, rather, the request was made for an amendment of... before I get to 30, let me just stop at Clause 27, because I did not address it, although it is on the list which we circulated. There is an amendment which has been proposed to Clause 27(1), and this is in respect of the final judgment. It is again in respect of revocation of a license. It had provided in paragraph G, 27(1)G, that one of the circumstances for revocation would be where a final judgment is obtained against a licensee and remains unsatisfied for a period exceeding 6 months. It has been raised, and in fact, we want to express appreciation to Senator Golding Campbell, who had pointed out that where a judgment debt had entered into an agreement, this might be circumstances where certainly borrower and lender had assessed the circumstances and found them to be one where a longer period may make sense, notwithstanding the existence of a judgment debt, which would be protective to the creditor in any event. So it has been proposed that the language that has been circulated be adopted, but it will be slightly amended because the agreement should indeed be in writing. So it will read, or such longer period as may be agreed in writing between the licensee and the judgment debtor. The judgment creditor, pardon me. So that amendment would, of course, precede the next point made. In clause 30, it had been asked whether it was reasonable that every licensee ensure that each substantial shareholder and officer remains a fit and proper person. And it is no amendment will be accepted to this. It is felt, and the policy is, that this is an appropriate obligation for a company in respect of its substantial shareholders and officers, as it is now. And in the banking sector, that is, these should be smaller enterprises, and where they are larger, then they should have the relevant mechanisms. There is, well, if it's a listed company, then it should have the mechanisms in place. And there is a defense under 33. The defense is that the licensee can prove that they took all reasonable steps in the circumstances to prevent a contravention, and that's quite a reasonable balance. So that amendment will not be taken on board. The fact, if there was no defense, I would say you might 30 sub 3. There's a defense in 30 sub 3, clause 30 sub 3. Right. The next request, clause 30 sub 3, sub clause 3. Right. The next request that was made was in respect of the scope of the appeals tribunal, but this again is a policy, and it is proposed that it could well be dealt with in regulations, that the persons may be the same, in the same way. So they would sit as a microcredit appeal when they're hearing something under, hearing a matter under this act, but they would sit as the banking services appeal tribunal when hearing under that act. So the aim is not to grow an institution of appeals tribunals, but it is, that is not necessary to be put in the bill. The next matter is, the next amendment to be taken on board is 43 sub 1 sub A2, and this is on the matter of the timing of the loan, sorry. 43 sub 1 sub A2, little 2. Right, so it's proposed here that the words "and disbursed" will be deleted. So the date on which the loan is made will be the operative date there. It must contain those particulars. So that's been taken on board. And the following is in respect of 43.2. 43.2 was the issue of escrow. So it's agreed that escrow is an expensive undertaking. So there was quite a bit of research done on the fly of this, and I really want to thank the team. But I'll thank them for everything at the end of this. In this particular matter, however, there is a proposed new clause. So we'll be amending it, and I'm going to just read it for you because the intention is now to use the SIPA, the Secured Interest in Personal Property Act, because really that's the only way that you can deal with the money, cash, as a security without causing other issues, shall we say. So the new clause, what is proposed is to delete 43.2 and substitute, therefore, the following. Where pursuant to subsection 1A4, property in the form of money is given as security for the performance by a borrower of his obligation, the money shall remain the property of the borrower, and the money shall be deposited in an account held with a deposit-taking institution and perfected in accordance, the licensee's security interest perfected in accordance with the Secured Interest in Personal Property Act. So the industry is not at a place where a micro is going to hold for a micro, and it's not there. It's not sufficiently mature, so the intention is to ensure that where deposit-taking institutions, it can be held more simply, the process would not be as expensive, and we feel that that is an appropriate balance for the concern which was raised. And the next matter on board is clause 45. So this is the provision which provides that a person who applies for a loan shall provide evidence of that person's ability to repay the loan. So I'm going to say something which I don't think anybody has heard me say before, and they may not hear me say it again. But I agreed with Senator Crawford's point. I agreed. And let me say, I didn't agree with. I have to circumscribe the aspect of the point with which I agreed, lest anybody think I agreed with everything you said, which for Hansard is not the case. But no, the fact is that we have some incredible business people in Jamaica, and they have learned on the streets. They have no certification, but they have minds that make use of every resource available, and that regretfully cannot always be reflected on a balance sheet or a proposed mapping of how to pay. So I am not endorsing the business plan for party holding which you have just reflected, Mayor. I do not endorse his methodologies. But recognizing it for what it is, and recognizing that this is intended to lift up and help and protect, and to balance that with growth and development. So we do have to recognize. So there are microcredit institutions who will require it. That's how they balance their risk. That's how they run their operations. And maybe, the guy with his $50,000 party and his profit of $200,000, that maybe he's not going to go to that institution. Maybe he'll go to another one that doesn't actually require. So that doesn't require him to prove how he will pay. So this is how the market will operate. So yes, I am, and we are in support of market forces, but markets fail, and that's why you regulate. So we're here to protect the failure, which is the inordinate and predatory practices that are being inflicted on our people. But we're finding the balance, and the balance I'm going to put before the Senate for clause 45 is the following. A microcredit institution may require a person who applies for a loan to provide evidence of that person's ability to repay the loan. So the obligation is now not on the borrower. The obligation is now or rather the discretion is now in the hands of the organization to say whether this is how I balance my risk, and I'm not lending if somebody can't demonstrate to me, and the borrower can choose that I'm going to go to a different organization because I need more flexibility. So that has been taken on board. So the next request that was made was in respect of the effective annual interest rate, and the assertion was made that there is an asymmetry in among the banks who are now competing with microcredits and don't have to disclose. But the code of conduct developed by the BOJ actually it had inspired this, as a matter of fact. The cabinet has, in fact, approved the comprehensive consumer protection legislation for the banking sector, and this will be required. So there is...
Just for clarification, yeah, I didn't want it to be restricted solely to banks and other financial institutions, because hire purchase companies was one of the examples I used where there is no transparent, effective annual interest rate in their financing. So I thought if it was included in the Consumer Protection Act or some more omnibus sort of application, that it would be helpful.
So there's no objection to any wider consideration about consumer protection. I think we're all agreed that consumer protection is important. But your reference to asymmetry within the banking sector, yes, you also referred to hire purchase and arrangements, which are not before us today. And I'm certain that no one would believe it to be a better way forward, that no one should have protection until everyone can have protection. So the microcredits, which we know are disproportionately impacted within the financial services sector with predatory lending practices, and we believe that this will now change that circumstance. So we don't believe that there is asymmetry required by this. It is important for regulation of this sector, and accordingly there will be no amendment taken to 46, which is in fact a clause that we've all, on this side certainly, celebrated today. 48, the request was that in respect of 48.4, I think maybe it had been missed that the amendment had been made before, or I'm not sure if I missed what the amendment was, but 48.4C was amended in the lower house. Oh, that it may, no, and right, and that's a drafting issue. No, the shall would create a statutory duty, which in the circumstances of an investigation is not appropriate. So we're not going to take that one on anyway. My note, my writing is not, well, it's far from. Clause 49. Clause 49 regarding the inclusion of representative organizations, mentioning them expressly. The fact is that the representative organizations are taken into consideration, and they have been included in all of the consultations, etc. What we would not want is to state it here and then have somebody show up with two friends who purport to be representatives. So, if we're to add in our relevant stakeholders, including but not limited to organizations purporting to represent the sector, you wouldn't want to then be told that the consultation was in breach because it didn't take everyone into consideration. The fact is that the Commission has huge experience with consultative approaches and recognizing who are relevant to sectors. So it is felt to be unnecessary to say anything further there. Their discretion we trust to be exercised appropriately. And then this takes us to 54.1. And 54.1 is the point on insolvency. And the proposed solution to that, so we thank you for this because this is definitely something that required an adjustment, is to include after the words Insolvency Act, the words or the Companies Act as the case may be. So 54.1, we will insert after the words Insolvency Act, the words or the Companies Act as the case may be. So it will include all the circumstances rather of a winding up. And the next matter to be addressed is that of 62, clause 62, where we were being asked to change the period within which the act is reviewed. And this is not being taken on board because the fact is that it makes no sense to put something that is unlikely to be practical. To count the number of joint select committees which are now established and to be established to comply with statutory, it's going to be quite a call on the parliamentary operations in order to go through them all. So we will keep it at 5. As anticipated, there will be 5 years worth of data, well, 4 years, because companies will take a year, will take their transitional year, and then we will move into, and then they'll collect data and have an even more robust basis on which to review the legislation. So again, I want to thank everyone for their contributions. I want to say in respect of Senator Webby's endorsement of comprehensive training on financial literacy, that this indeed is not important only for persons who intend to borrow, but certainly for the Jamaican population as a whole. We really do need to expand the financial literacy pilots which have existed at the primary level, expand them, and make them available perhaps through the JFL courses, which have also a broader remit that you take with your remedial English and math. You also take your basic financial literacy so that you can understand what it is, what an interest rate is and what it means, and it will complement the rollout of the protections provided here under. I want to endorse as well the statement that was made that we have highly professional and effective microlenders who are really performing a great service as they meet the needs of the market. As Senator Webby, as you said, the fact is that the size of the industry, the $10 billion industry, certainly reflects that it is a need which exists, and certainly the familial and other circumstances pointed out earlier by Senator Campbell Rodriguez and Senator Longmore cannot also be understated. So with that, Mr. President, I thank everyone for their contributions and ask for a second reading of the bill.
Thank you, Minister. The question is that the bill be read for a second time. Those in favor? Aye. Against?
A bill entitled An Act to License and Regulate Microcredit Institutions that provide financing to individuals and micro, small, and medium-sized enterprises, and for connected matters read a second time.
Thank you, Madam Clerk. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. Thank you very much, members. There are a number of clauses to which there are amendments and quite a few to which there are not, but if you indicate as we go along, maybe I can take some of them en bloc. I put clause 1 of the bill. Those in favor? Aye. Against? Ayes have it. There is an amendment to clause 2, which is on the amendment sheet. So I put the amendment to clause 2. Those in favor? Aye. Against? I put clause 2 as amended. Those in favor? Aye. Against? The next amendment is to 6. Can I put clauses 3 to 5? Aye. Those in favor? Aye. Against? Ayes have it. There is an amendment to clause 6. Leader?
Yes, Mr. President. The following is proposed. Clause 6(1)(c) is deleted and the following substituted therefore. Disclose, other than for the purposes of the investigation or prosecution of a financial crime, or in relation to the contravention of a licensed obligation under any other enactment or upon the presentation of an order from a court of competent jurisdiction, comma, any information obtained in relation to the performance of their duties under this Act.
Members would have heard the proposed amendment. Those in favor?
Aye.
Against? I put clause 6 as amended. Those in favor?
Aye.
Against? Ayes have it. I put clauses 7 to 13. Those in favor?
Aye.
Against? The ayes have it. There's an amendment proposed to clause 14. Minister?
Yes, Mr. President, and it remains as on the list circulated.
So I put the amendment to clause 14, which amendment is contained on the relevant sheet. Those in favor? Aye. Against? The ayes have it. I put clause 14 as amended. Those in favor? Aye. Against? Ayes have it. I put clauses 15 to 24. Thank you for the assistance. I put clauses 15 to 24. Those in favor? Aye. Against? The ayes have it. There is an amendment to clause 25.
Yes, Mr. President, thank you. It is proposed that clause 25(1) be amended by inserting immediately after the words contravened or is contravening the words a condition of its license.
Members should have heard the amendment. Those in favor? Against? Ayes have it. I put clause 25 as amended. Those in favor? Against? Ayes have it. I put clause 26. Those in favor? Against? Ayes have it. Clause 27, there is an amendment there too.
Yes, Mr. President, and I'll read this one just because there is an amendment to the sheet. The amendment is to delete paragraph G and substitute, therefore, the following. A final judgment is obtained against the licensee in any court in Jamaica and remains unsatisfied for a period of 6 months or such longer period as may be agreed in writing between the licensee and the judgment creditor.
Members would have heard the proposed amendment. Those in favor? That's the amendment to the amendment. So I put the amendment as amended. Those in favor? Thank you very much. And I now put clause 27 as amended. Those in favor? Aye. Against? Ayes have it. I put clauses 28 to 43. I put clauses 28 to 42 as there is a proposed amendment to 43. 28 to 42. Those in favor? Aye. Against? Ayes have it. The Minister, 43.
Yes, thank you, Mr. President. It is proposed that clause 43, subclause 1A, paragraph 2, be amended by deleting the words "and disbursed," which appear at the very end.
That's it? Members would have heard the proposed amendment. Those in favor? Aye. Against? Ayes have it. I put clause 43 as amended. Those in favor? Aye. Against? Ayes have it. I put clause...
Sorry, that's 43 1A2, and there is now an amendment to 43 sub 2. Yes, my apologies. Yeah.
Go ahead.
Mr. President, it is proposed that 43(2) is deleted and the following substituted therefore. Where pursuant to subsection 1A(4), property in the form of money is given as security for the performance by a borrower of his obligation, the money shall remain the property of the borrower, and the money shall be deposited in an account held with a deposit-taking institution, and the licensee's security interest perfected in accordance with the Secured Interest in Personal Property Act.
Okay, members.
Just a clarification.
Yeah.
Deposit-taking institution, does that include a credit union, or credit unions would be omitted from this scheme?
They would include, deposit-taking institutions would include credit unions, I believe.
That's what I'm trying to confirm, if that's
Yes.
in the definition.
Yes.
An amendment again to 43. So I put that amendment. Those in favor? Aye. And I put 43 as amended. Those in favor? Aye. Against? Ayes have it. There is no amendment to 44, which I put. Those in favor? Aye. Against? Ayes have it. 45, there is an amendment.
Yes, Mr. President. The amendment is to delete clause 45 and substitute, therefore, the following. A microcredit institution may require a person who applies for a loan to provide evidence of that person's ability to repay the loan.
You have heard the amendment. Those in favor?
Aye.
Fine. I put 45 as amended. Those in favor? Aye. Against? On my estimation, I can put 46 to 53. Those in favor?
Aye.
Against? Ayes have it. There is an amendment to 54.
Yes, Mr. President. Clause 54(1) is amended by inserting immediately after the words Insolvency Act, the words or the Companies Act, as the case may be.
Thank you very much. Members would have heard. Those in favor of the amendment? Against? Ayes have it. I put clause 54. Clause 54 as amended. Those in favor? Aye. Against? The ayes have it. I think I can put 56 to what? Thank you. Clauses 56 to clause 65, I'm sorry. Come again? Again. Clauses 55 to 65. Those in favor? Aye. Against? The ayes have it. There's an amendment to the fourth schedule, so I can put first, second, and third schedules. Those in favor? Aye. Against? The ayes have it. Madam?
Thank you, Mr. President. In the third column, in relation to the penalty for the offense under section 9.2, or the amendment is, in the third column in relation to the penalty for the offense under section 9.2, A, this is the first amendment, in paragraph A, delete the words $1 million and substitute, therefore, the words $2 million. And B, in paragraph B, delete the words $500,000 and substitute, therefore, the words $1 million. And this is the offense of operating without a license.
Thank you very much. Members, those in favor of the amendment? Those in favor? Aye. Against? The ayes have it. I put clause 4, I put the fourth schedule as amended. Those in favor? Aye. Against? The ayes have it. I put the fifth and the sixth schedule. Those in favor? Aye. Against? The ayes have it. I put the title and enacting clause. Those in favor? Aye. Against? The ayes have it. The question is that I do report the bill as having passed committee stage with 12 amendments. Those in favor? Aye. Against? The ayes have it.
Mr. President, might I ask for third reading of the bill?
Thank you. Yes, I need to just say it one more time. I do report the bill as having passed committee stage with 12 amendments. Ministers asked for the bill to be read a third time, and that question is put. Those in favor? Against? Ayes have it. Madam Clerk.
A bill entitled An Act to License and Regulate Microcredit Institutions that provide financing to individuals and micro, small, and medium-sized enterprises and for connected matters, read a third time and passed.
It would be remiss of me not to thank the members of the Senate for their contributions today. The bill is not one that is without complexity and was of some length. So I appreciate all the contributions, and it would be equally remiss of me not to identify the skill with which the minister responsible negotiated and piloted this bill today. Thank you very much.
Thank you, Mr. President. Mr. President, it is not intended to do any further business today. What? Well, you know I can. And I don't have to be pressed too hard either. I was just saying that. But just to again, Mr. President, thank the technical team that worked on this bill and to express my appreciation. So this is the team from CPC, AG's Chambers, Consumer Affairs Commission, Ministry of Finance, and the Bank of Jamaica, who are all present here with us today and who have been working through to make sure that we paid as much attention as possible. I want to thank in absentia Minister Clark, who has also been giving guidance by WhatsApp, ensuring that the aims of the bill remain on track and that flexibility is demonstrated where it has been justified. So again, I want to thank everyone for their presentations and to thank the team for their support and ask, Mr. President, that the Senate be adjourned for a date to be fixed.
Thank you, Minister. The question is that the Senate be adjourned at 10 minutes past, quarter past 4 for a date to be fixed. Those in favor? Against? The Senate now stands adjourned.